Well, once again, welcome everyone to webinar number 4 regarding training. We do not anticipate that this will take the whole 90 minutes. We think this is probably more like an hour session today. So I think maybe everyone will appreciate that. So we're going to start off with notifications. Brandy, to you.
All right, so the regs are pretty clear about your notifications. Similar as before, you have to designate at least one Title IX coordinator. The regulations are clear that you could have more than one if you choose to, but that individual or individuals, as the case may be, is responsible for coordinating all of your institutional efforts to comply with Title IX on both the employee and the student side. You have to provide the name or title of that person, and this is an area where you might think about maybe title's best because that person may change over and it keeps you from having to update a number of things. Their office address, email address, and telephone number. You have to provide it to a very specific group of people, and that includes any applicants for both admission on the student side or employment on the employee side, to existing students, parents or legal guardians of secondary school students. We don't have to worry about that. Employees, and then one that probably doesn't apply to any of you, unions or professional organizations with collective bargaining rights.
So Brandy, is this very similar to our notices of non-discrimination that we've been doing for a while?
Yes, it's just more specific on exactly what you have to require. Another thing in addition to that I should probably know is on the email address you select, you might also consider a generic Title IX email address that goes to your coordinator. So again, if the person changes, you don't have to worry about updating a number of things with that specific person's email address. You could have a like title9@institution.edu, something like that might be something to consider.
So in previous OCR program reviews and investigations, one of the typical, they have data collection sheets that they send out to everyone. And one of the very first things that OCR requests in a data collection is explain to us and show us and provide the documentation to support all of the different ways that you make these individuals aware of the Title IX coordinator and their information. And so as you're doing this, you would probably want to keep documentation so that it is easy to gather really at a moment's notice because in all recent, the last 9 or 10 years, both program reviews and individualized investigations of allegations of a violation of a policy that OCR looks at, they request the same information.
And I think the next slide kind of piggybacks on that. This is kind of where you need to put everything. So your website, kind of easy one. And then all of that should be contact, not contract, sorry, y'all. Any of your handbooks, catalogs, anything like that. The easiest way is tack it onto your notice of non-discrimination and include it there. And then you've got an easy way to make sure you're getting it in everything. It's standardized, whether it's one department putting it out or another, you don't have to worry about that. And you have an easy way to collect that if OCR knocks on your door and asks for that information. Again, notice of non-discrimination. This is just saying you have to add to that you don't discriminate on the basis of sex under Title IX. You also have to state that you don't discriminate in your education or program activity, and that extends to admission and employment. So again, just beefing up that, making sure whatever non-discrimination statement you have complies with all of these requirements. And that's why these are the exact regulatory requirements, and we put them in here just so you can find them easily. The more robust one is publishing your grievance procedures that comply, all the things we've been talking about that you have to do. You have to publish those procedures and then provide notice to those same people about how to file a complaint, or I'm sorry, where to report, how to file a complaint, and then how the institution will respond. And then another one that we're going to talk more about today is you are now required to publish all of your training materials publicly on your institutional website, or if you don't have one, and I struggle to think of any institution that doesn't, but in the event that you don't, you have to make the materials available upon request by a member of the public. This is a very, very new requirement and one that is likely going to be met with some consternation, particularly from groups like ATICSA and others who charge for that training. They've developed that proprietary material and they're not wholly willing to let it go and be published on your website and become available to anybody who wants to use it, because that's how they make their money. So ATICSA at one point had suggested that institutions only publish the names of the trainings that they've done and not the actual materials. OCR responded with a blog post that's included in the notes section of these slides that you'll get, and basically said, no, that is not sufficient. We meant what we said, and that is post all of your training materials on the website. So that's an area that is probably ripe for some litigation in the future, and we'll kind of see where that lands. But for now, the requirement is you have to publish it. So if you are using an external third party's training materials, you need to make sure ahead of time that you're going to be allowed to publish those. Otherwise, you won't be able to meet this requirement.
Thank you, Brandy. Have you checked that blog lately? It is fascinating.
It is interesting.
Yes. So if you aren't familiar with the OCR blog, this is the first time that I'm aware that OCR has ever created a blog and kind of monitored it with regularity. Well before the Dear Colleague letter, they were not doing this. And so this is kind of a first. And so if you look in the notes section, Brandy has the final link there is to this blog. And it was most recently updated on July the 7th to include some additional training. It's a YouTube video. It's like 16 minutes from the Department of Education regarding how institutions are expected to handle matters of sexual assault. Previously in May, they had published information about sexual harassment. There aren't a lot of notices that go out whenever they place something new on the blog. It's just kind of up to us to continually review it and to see what has been added. It's interesting because these are not Dear Colleague letters. They're not guidance. They really are just posts that do provide some insight into how the Department of Education is viewing some questions that they receive on the regulations. It's my understanding that a number of personal interest groups have submitted questions to the Department of Education, and that is one way that they are receiving responses is through these updated blog posts.
So it might be worthwhile to bookmark the link that's in your notes and make a note, check in once a week, every other week, however much this interests you, I guess is up to you, to see if there is anything new on that post, because that is a unique way that OCR is communicating with, or the Department of Ed is communicating with institutions. All right, so now what are the actual training requirements? So the first is who has to be trained. Obviously Title IX coordinators, investigators, decision makers. And then the last catch-all is any person who facilitates informal resolution process. So if your institution plans to utilize that process, you have to make sure those individuals are trained. So what do you have to train them on? And the regs are very specific. First, the definition of sexual harassment should be easily covered in your policy. Second, the scope of your educational program or activity. Again, this should be outlined in your policy. How to conduct an investigation and grievance process, including hearings, appeals, and informal resolution processes as applicable. And then how to serve impartially, including by avoiding prejudgment of the facts at issue, conflicts of interest, and bias. So these are the last two are basically how do you actually implement this policy and all the things we've been talking about in these webinars. How do you get from point A to the end? And that's what those last two pieces cover. And how do you do it fairly and impartially and make sure that everybody involved in that process knows what they're doing?
So then there may be beyond just who is required under the regulations to have training, then there's the pot of people who probably need to know what's going on. And so who may need training, in addition, would be appeals persons or appeals panels, which are a form of decision making. Now, although institutionally provided advisors are not part of the litany of people who are required to have training under the regulations, I think it would be advisable if you're going to be providing institutionally provided advisors, especially if you're going to take the approach that they do not do openings or closings. They really are only there for the cross-examination piece. There is no way that a person would know that that is their role unless they have received a significant amount of guidance regarding that. non-decision making chairs for panels. If you're going to look at someone like we discussed in webinar 3, where you may have someone from student conduct kind of making sure that the process goes how it's supposed to, that could be an idea. Because there are so many changes with Title VII and how this impacts employees, I would suggest that the HR may appreciate a heads up on what all of these different rules are, as well as if your legal department, particularly if you're using outside counsel, this may not be something, given kind of the current state of affairs with the pandemic, that is really something that they're deeply involved in. Those of us that are in-house, of course, are really up to our eyeballs in this. However, that may not be the same for everyone. And then if you have an ombuds person, or a person who, it acts like the ombuds, that would be another person who would want to have at least a threshold amount of information about what's going on. So these are additional people you might want to consider in training.
And one pot of people I realized that I left off there is your responsible employees. You still got to train whoever you choose to designate as responsible employees. You're still going to have to train them on what does that mean? What is your role? When do you report? Who do you report to, etc. And then you might also consider, and I know this has been a request specifically at some of our institutions, an executive level type training. Train your exec team on what does this mean? Make sure your president knows, your vice presidents know, because they need to understand the process too. They're going to get questions and they need to be able to explain it. So moving on to more required training. So your decision makers have to be trained on any technology if you're going to use it. They also have to be trained on issues of relevance. How do you determine relevance of questions and evidence, and specifically including evidence about the complainant's prior sexual history? And we covered that in webinar 3 as well. Investigators in particular must be trained on issues of relevance, and they need to be trained on how to create an investigative report that fairly summarizes the relevant evidence. I cannot stress the importance of this one enough. Those investigators need to know what they're doing. They need to have a good guide into how to create that report. Their report should be consistent in terms of how they are prepared. They should generally look the same as each other. So consistency, and then making sure that they understand they have to put in all the relevant evidence. So that investigator has to be able to identify what needs to go into that report and give your decision makers all the information that they need to make decisions. And then lastly, the department did not go as far as requiring annual training. Instead, they said basically, we're not going to give you a requirement on frequency. We leave it up to institutional discretion as to how often you want to do that. Having said that, you need to make some institutional decisions about how often you're going to do this. Are you going to train annually for those who serve continuously in these roles and particular decision makers? Are you going to train only as often as you put new people into those roles? How do you want to establish that? So that's something to think about on the institutional level. As far as training materials, the department did not give a lot of guidance. Basically, they just said that the training materials cannot rely on sex stereotypes, and they must promote impartial investigations and adjudications of formal complaints of sexual harassment. Outside of that, other than the requirement that you have to publish, the department did not weigh in on what the training should look like, nor did they provide sample training. It said institutions have discretion to determine what that training looks like for their institution. This leaves, as you might guess, a gaping hole for institutions to figure out how in the world do we actually do this.
Which leads us wonderfully to drafting your institutional training. And these, this is not the regulatory guidance. This is kind of our practical advice of having been around the block with Title IX for a while, and the various requirements of training that have evolved with the Department of Education's guidance, our thoughts about maybe a way to do this. And so first off, starting with, these are my personal pontifications for a minute. I would really consider looking at one slide deck or one very large packet approach, where you take all of the materials that are required, regardless of the individual to be trained, and you put it in one large packet. And that could either be in a slide deck, or it could be a slide deck with a number of Word documents in it as a physical attachment in one big PDF. And the reason why I would do this, there's a number of reasons. Number one, I think it makes whatever you're then going to place up on your website to be very consistent throughout all of the different individuals that you're going to train. It also makes the one initial drafting of this very consistent, and then the revisions, if you need to go back and revise to be consistent. And then whenever you're doing the training, you could make it a series, kind of like how we've done here, make it a series. And the parties who need to be trained, right, clearly you're going to focus your attention on certain parts of those materials at much more lengthy for, let's say, decision makers and appeals persons than you would for an informal process facilitator. And so where you spend your time in the training would be different, which really leads to the ultimate question of who is going to provide the majority of your training at your institutions. But because we now have Title IX coordinators who can be investigators, however, there is no longer one single investigator model. They're not going to be involved in all of these areas. Many Title IX coordinators may not be investigators anymore, which I think provides them a wonderful opportunity, particularly if they are long-serving Title IX coordinators, to be at least the initial folks who develop and compile all this information and act as that internal expert and thus the internal trainer. You may also have deputy Title IX coordinators who could act in that capacity as well and really gather together all of that as a whole. And the reason why you need to think about who's going to provide your training is because much of the training is going to be very unique to your institution. And so when thinking about your large deck or your packet of materials, the first thing you're going to want to include is your final policy, which makes the timing of this training a little bit challenging, because I don't see a way that you could do a large scale training for all of these folks without first having your policy finalized. I think it's going to need to be final first, because so much of what you're going to need to train on is going to be found in your policy, or if not exactly in your policy, in the processes that you're going to write to supplement your policy. So you're going to include a link or the actual policy itself, and you're going to talk about the definitions of sexual harassment, exactly like how we talked about them in webinar 1, right? With the issues of sexual assault, and then dating violence, domestic violence, and stalking, and with a hostile environment and quid pro quo. You're going to have those same kind of conversations with this group. And then how you've defined the scope of your program and activity. It has to be in your policy. You're going to want to highlight that. How to conduct an investigation. So I would, this is such an important and critical area of training. And likely you are using investigators that already have a wealth of training. And likely have been through numerous previous investigative training modules, because I would posit that now is probably not the time to bring in investigators who've not had training before. That would be a unique situation. And so I would really think about outsourcing this area of your training and providing someone's the ability to go to investigator training through a third party. There's many that provide this, ATICSA, the SUNY, Student Conduct Institute, and many others that provide this outside investigator training. Because of the pandemic, almost all of that has gone online, so it makes it a little bit more accessible without the need for travel. When we think about how to conduct a hearing, very similar to how Aaliyah walked us through in the last webinar, you're going to want to explain what is the setup of the hearing, maybe even have a physical description of what that looks like, or show folks how that's going to work on Zoom. And then walking the parties through, not the parties, but rather walking the individuals who are going to conduct the hearing, the decision makers, through the hearing script. I can't stress enough how important it is to have a hearing script. And walking them through that hearing script will get you very far down the road of how to conduct the hearing. And then you're going to have to spend some very significant time on how you question regarding relevance. And so in the Dropbox, we have created a relevance worksheet. And that relevance worksheet, I would strongly encourage you to review. In the relevance worksheet, the purpose of this worksheet is, I'm making some assumptions that people may not be able to go out and get third-party training for a while. Your Title IX coordinator needs to teach a hearing officer or decision maker or a decision-making body what does relevance mean and how does it work. Please feel free to use the Word document titled the Relevance Worksheet to walk through this. Because the Relevance Worksheet goes through, number one, what is a relevant question? And cites directly to the regulations. One thing you may want to notice in this document, much of the regulations are based upon the Federal Rules of Evidence, specifically Federal Rule of Evidence 401 and 402. And I get it that the rules of evidence are not incorporated into our processes. However, the commentary to the rules of evidence are very helpful in understanding, at least from a federal judiciary perspective, what's relevant and what's not. And so I've included the comments to the federal rules in this document as a way of reflecting, I think, perhaps what was somewhat embedded in the regulations. And then it goes on to talk about what if the question concerns a sensitive issue, and then what I think is incredibly helpful, what questions may be irrelevant. Whenever you get to questions about prior sexual behavior or prior sexual predisposition, it is not relevant unless it meets one of two exceptions. And so in these two exceptions, I've included a number of footnotes from the commentary to the federal rules about how did the people who are writing the federal rules think about defining sexual behavior. That terminology is not defined in the regulations for this purpose, but it is defined in the commentary to the Federal Rules of Evidence, which is a good place to start looking. And so you'll really want to pay attention to footnote 3 and footnote 4 in the document. And then questions regarding privileged information, whether or not that privilege comes from medical providers or clergies or rape crisis counselors or social workers. And I've provided footnotes that go to the state statutes regarding all of those different types of privileges. So things that you can review. And also about duplicative questions. But I think probably one of the most helpful parts of this document is on the final page. Options for explaining on the record whether a question is relevant or not. And this document is intended for the decision maker to have in front of him or her. And whenever you get to a question and you have to make a determination of relevant or not relevant, what analysis are you going to go through in your head? And then what are you going to say on the record about whether it's relevant or not? Assuming that for a minute you may not be able to afford or to use a decision maker outside of your institution who does this with frequency. And this is something that you just have to, because of the current set of circumstances, use someone internal to your institution. You're going to need to help them understand way before the hearing. What are you going to say on the record about whether or not a question is relevant or not? And so this really goes through, for general questions, how am I going to make that decision? For the complainant's prior sexual behavior, what am I going to say? If it's relevant, I'm going to say this. If I deem it's not relevant, I'm going to say something different. And it goes through all of these matters. And so that may be something you want to use or modify for your institution to teach not only what's relevant, how you make that determination, and then how are you going to present that verbally during a hearing as a decision whenever the question is made. So that is in the Dropbox for you to review and use however you see fit in your training. In addition to conducting the hearing, you're also going to have to teach how to draft a determination. And this is where the forms that Aaliyah talked about in webinar 3, I think are absolutely critical. That if you're going to teach a decision-making body how to conduct a hearing, that includes What is it that you want them to give back to student conduct or to produce that has all the requisite information? And so if you use a form that they're going to complete, then showing them the form, teaching them what to put in each area and things that they need to consider, and then who they're going to provide that. Very similar information about how to conduct an appeal. You're going to want to train on what are the packet of materials that an appeal person can anticipate to receive, and how can they anticipate to receive this information? Are you going to provide that to them in paper or SharePoint? And then what information is proper to consider? This is incredibly important, particularly if you're going to narrow the appeal to just a paper appeal, which we would highly encourage. There's some previous interesting litigation before the finalization of these Title IX rules about appeals panels or an appellate person who would call the witnesses from the original hearing and ask them questions, or call the panel and ask the panel questions. And that caused a lot of problems because it was deemed kind of its own additional hearing instead of an appeal process. And so if the expectation of your institution is it's a paper appeal and you're only going to review and make a decision based upon what you're presented, you're going to want to emphasize that significantly, right? This is all we want you to look at. And then also your bases for appeal. As we talked about in our previous webinar, there are 3 limited bases for appeal. Many institutions will decide that's sufficient enough, and we're not writing additional bases. And if that's your decision, that's great. Or if you're going to add more, you just need to really explain to the appeals folks, what are those bases and what does that information actually mean? And then how to write an appeal decision, similar to how you did with the hearing panel and the decision maker form. If you have an appeal form, explaining that appeal form and then how you complete that. If you are planning on completing and using informal resolution, I think this is one of the most unique areas where training is mandated, but really no insight is provided into what type of training we would need for those informal resolution facilitators. And so clearly, in order to create an informal resolution, you're going to have an underlying knowledge of how the process works and how supportive measures work. And so having informal resolution facilitators have a broad understanding of the process will be critical. But I think the training also needs to be something more than just understanding the process, but also understanding actually how to complete an informal resolution. And if you're fortunate enough to have some individual who's already trained on alternative dispute resolution or who acts in a mediator in other capacities, that's fantastic. But for many of us, we may not have that. And so I would strongly consider looking at mediator training, because that appears to be at least one avenue of additional training that informal resolution facilitators need that is also readily available through either continuing legal education or even non-legal mediation training. Finally, looking at the 2 final things we need to make sure we cover are prejudging, conflict, and bias. In addition, in your Dropbox, there is another Word document titled Conflicts of Interest, Bias, and Prejudging. And the idea of creating this document is to outline what does the Department of Education consider to be a conflict of interest. And so the document goes through the definition of conflict of interest. But interestingly, the regulations also identify a number of areas that are considered not to be an automatic conflict. Rather, you need to analyze those on a case-by-case basis. Those include an individual's professional experience, particularly an individual who has done previous advocacy work, either for respondents or for complainants or victims. And so that is previous work as an advocate or in the advocacy community does not necessarily conflict you out of even being a decision maker. That's going to have to be analyzed, and you're going to want to explain that in your training. Also, what does not automatically conflict you out, thank goodness, or we would be outsourcing everything, is whether or not you're an employee with the institution, which I would think would go without saying that that couldn't conflict you out, lest all this be done by contractors, or if you're affiliated with the institution. Also, on a matter of prejudging, the final rules, there's a whole section in this Word document about kind of how is prejudging defined, and I would call your particular attention to footnotes. I feel pretty ridiculous saying footnote 1052 through 1054, but they actually are very insightful because they include a wealth of academic research and articles regarding the issue of prejudging and a presumption of what we say in student conduct of non-responsibility, although they adopt in the footnotes kind of the criminal component of a presumption of, quote, innocence. But in the footnotes, it has a number of articles that would be worthy, perhaps, of reading or picking out a few to include in this training, as they are clearly reflected in the footnotes, and thus the Department of Education has in some form relied upon them for their commentary response. You may want to pay particular attention to footnote, I think it's 1054, that cites a 2002 Oklahoma Law Review article. So we have some information that's even more close to home, which handles this exact issue. In addition, if you really want to delve into bias and prejudging, there's a 4-part series from the End Violence Against Women International organization, and I have studied this 4-part series. Now, it is not a webinar. There is no audio-visual component. It's a self-learning, kind of self-paced 4-part written series. However, they're titled Gender Bias in Sexual Assault Response and Investigation. It includes not only concepts of Title IX, but also in the criminal component and with law enforcement. And it is very instructive. The materials for the End Violence Against Women International have been cited over and over by the Department of Justice, Office of Violence Against Women, and those, although not currently cited on the Department of Justice website, recently archived websites have cited this. It's a known provider of very quality training. And so I wanted to provide that. In addition, the Department of Justice issued 2 years ago training materials for law enforcement regarding gender bias in sexual assault investigations, and that is also included on the document. And so our hope is that you could use both this conflicts of interest document and the relevance document in drafting the materials that you need that are outside of what's in your policy to get you very far down the road in your training. Really, the only thing that's not in your policy or not in these 2 documents would be your investigator training, the training you need specifically for your investigators, which we would strongly suggest you outsource. And then finally, probably the easiest part of this whole thing, is the technology you will be using for your hearings. And depending on what technology you're using, providing training modules for that, and using either the vendor's training modules or your own IT personnel to provide training. If you have completed training in the last, 3, 4, 5 years, you're going to want to, particularly for your Title IX coordinators, investigators, and decision makers who likely have been with you, particularly your investigators and coordinators, for a while. You're going to need to go contact all those individuals and see, will they allow you to upload their training And, well, have you kept it? And assuming you have kept the materials, will they allow you to upload it? Because you're going to have to upload this to the website. And what disclaimer or link or other information they may want attendant to that training. It's come to my attention that numerous vendors are allowing individuals to upload, but they want some type of disclaimer language associated with that. And so there's nothing in the final rules that says, it says you have to put up all your training. It doesn't say, and in addition, you can't have disclaimer language. So I would anticipate everyone's will be a little bit different. You're going to want to go ahead and check on that. It has also come to our attention that SUNY will be providing what they perceive as compliant training to the federal regulations through their Student Conduct Institute, and they're going to allow everyone to post it. For many institutions, it is going to be very difficult to get the policy drafted, because that's really what our 4 webinars have been about. What has to be in the policy, right? And that it may just appear too daunting to also turn right back around and draft all of this training. And so if there was the ability to scrap together a little bit of money to become part of either TICSA and using some of their training, or SUNY Student Conduct Institute and using some of their training, that may be a real option that people want to consider if this whole amalgam of requirements feels very daunting.
Nothing daunting about it. What are you talking about?
So, Brandy, perhaps you would want to share your PDF of the training opportunities on the screen. I think that might be very helpful for people.
Let me see if I can get there. Hang on just a second.
Share real quick.
Sure. Give me just a second.
Absolutely.
All right.
And while you're doing that, we have one question.
Go ahead.
And it goes along exactly with what we're talking about here. And so in your, Mike asked, in your opinion, is a self-study syllabus and materials sufficient for training, at least at the coordinator level, or would attending a conference presentation prior to August 14th be 100% necessary?
My advice on that would be, it's the best you can do by August 14th. I think if you getting to training before then may not be doable, so post whatever you can. If you've kept up with that, for many of you who followed Mackenzie's presentations in particular, you've used that model of a self-study syllabus, which I think is what you're referring to, and kind of tracked what trainings you've done. As long as you can post the materials from those on your website, then that should at least get you down the road on it until you're able to do any additional training. Mackenzie, what are your thoughts on that?
I think totally. I think that's accurate. I think that particularly for the Title IX coordinator and the investigator. So in the process of who's going to go first on this, in terms of who's going to have to know enough to be able to do what's expected, the Title IX coordinator and the investigators are on the front end of that, right? There's a lot of things that may happen before you ever get to the decision maker part. And so if I was looking at how do I prioritize, who do I absolutely have to get training first, I would have our Title IX coordinators and investigators pull together all the training materials they've had, and I would probably go back 5 years, because there's a lot of concepts in the regulations that have not changed. And then I would make my best effort before August the 14th to have at least 2 or 3 couple hour sessions to go through what we know are new in the regulations. And I would really strongly look at what's on our slide 15 and 16 as topics minimally that you need to cover in those, and make sure you've at least checked those boxes for the Title IX coordinator and the investigators. And then I would have a planned, scheduled training that I don't think you're not going to have a decision maker make a decision on August 14th. So you got some time for the decision makers, and maybe even a little time for the informal facilitators, definitely more time for the appeal people. And I would put those in round 2 after August 14th, and then go ahead and get that on the schedule. But I do not think that it is imperative, based upon how the regulations have been written, that someone attend a conference before August the 14th. I think that can be somewhat cobbled together. I think it is, that's what's in the regulations. Time will tell how that is interpreted during an investigation. And we're not going to know that for another probably 9 months.
So in your Dropbox, there's a list of training opportunities, and this, I should caveat this with this: these are free training opportunities. There are a whole bunch out there that you have to pay for that are very worthwhile if your institution can afford it. But this specific list was designed with the fact that nobody has any money, and we kind of know where you're coming from on that. Some of these are older and pre-recorded webinars. Excuse me. The first is a list that Department of Education put out. Some of those you have to pay for, some you don't. The second is the National Center on Domestic and Sexual Violence. They have a list of trainings that are available. I highly recommend bookmarking that site. Same on the State University of New York Sexual Violence Prevention webinars. The downside of the SUNY ones is they don't archive them. So if you miss that, they usually offer them twice, and so you have to sign up in advance. They don't have any currently scheduled, but I highly recommend bookmarking that site and checking in periodically. Another place to look that I did not put on here, the National Center for Campus Public Safety. They have an overarching events calendar that a number of entities submit events to, and you can search that by webinars. I checked, there's currently nothing scheduled, or I would have put it on here for you. And then there's a number that these are all hyperlinked, so you can just click on them. And all of these are free and easily accessible. You may have to register or fill something out, but you can still get to the training without paying anything. And they cover everything from report writing to programming, because one thing to remember as we move through this is the VAWA requirements are still out there. They did not go away with these new Title IX regulations. So your educational and programming activities that you've been required to do are still required. So if you haven't in a while, because nobody's been overwhelmed by this at all, or COVID or everything else going on, you might refresh yourself on Chapter 8 of the Clery Handbook and what's required under the Violence Against Women Act. And some of these trainings will help you get to some of that. So for example, beyond orientation, building a prevention calendar at a college or university, that might help you with your VAWA requirements. So there's a host on here. A lot are really targeted at your investigators, particularly this: how do you interview victims, things like that, writing an investigative report. And then there are some that are very specific to sexual assault, stalking, dating violence, or domestic violence. I would also pay close attention in September. It's National Campus Safety Awareness Month, and there are usually a host of free webinars that become available during that time. That obviously doesn't help you with your August 14th date. But as Mackenzie said, there's really only so much you can do by August 14th. We're not expecting you, or Department of Ed is not expecting you to be able to hold a hearing on August 14th, because you just won't be there yet. So paying attention to what's out there and what's free, and bookmarking some of those sites so you can share those as they become available, will be important for your institution.
Fantastic. Now I'm going to look at the chats and see what we have here. Forgive me, but we are at a training, and we talk about not getting trained yet. For instance, I have been through a TICS investigator training, and have been through training on Title IX changes. What else? Right. So I think that is absolutely wonderful for Title IX coordinators and Title IX investigators. Part of what we're trying to explain is that there are a wealth of other people in the continuity of the process that are going to require training. So your informal facilitator, your informal process facilitators, your decision makers, right, your appeals folks. So all of these folks are going to also require training as well, and that there's mandatory components of training. And I think what often gets confused is, teaching people what's in the regulations and how to write a policy, and then the institution teaching folks in their institution what's in the policy and how to execute their process that's already been designed, right? And so what we intended for these webinars was the first of this. Here's what's got to be in your policy, right? And then we have to do the hard work at our institutions of drafting the policies and then drafting that secondary training of teaching people at our institution how to execute the policies. I don't see any additional questions or comments. Brandy, boy, we went quickly today.
Yeah, this is really just kind of intended to be an overview to help you get started on some of this. I do think it's probably going to be in your institution's best interest to consider an outside vendor, as Mackenzie mentioned, for some of these things. Not going to plug anyone in particular, but check into what's out there, see what you can use, and then get started and just get as far as you can on it.
I would be happy to stay after if people have questions regarding the training opportunities or the Word documents that we posted on Dropbox. I'd be happy to answer any of those. Other than that, that completes our fourth part of our webinar series. We have recorded all of these. We have arranged for them to be captioned, and as soon as the captioning is complete, we will make those available to you all. If they don't fit in the Dropbox, we will post them in a different location and make you all aware.